My name is Joe Loveland. I'm an arbitrator and mediator. I practiced law for a little over 40 years at King & Spalding here in Atlanta. I had a trial and appellate practice that took me all over the country. I did mostly business litigation, but also did class actions, mass tort cases, intellectual property, etc. I decided to pursue ADR when I finished my time at King & Spalding because my experience showed that both through mediation and arbitration, my own clients were able to achieve quicker, better results. Frequently in mediation, you can do creative things you can't accomplish in litigation. In terms of how to help parties reach a resolution, the most important thing that I think that I bring to the table is understanding the facts and the legal issues fully. I explain it frequently that I'll never know the case as well as the lawyers. They've lived with it for a long time. But I'll hopefully know it better than the judge who they would ultimately be in front of if they don't settle the case. I think my mediation style is twofold. First, I really try and establish a relationship with the principals. I think that's critical to trying to earn trust and have them develop confidence in what you're doing. And secondly, I try and make sure the lawyers know I'm not trying to supplant their legal judgment. I'm providing a fresh perspective and a fresh set of eyes. Really, that's the core of what I do. The way I prepare for mediation involves, first, making sure I speak separately with the counsel for each of the parties. I usually ask them to prepare a mediation statement to brief me on the case. I want to understand the facts and I want to understand the legal issues thoroughly before I sit down and start talking with the parties. For arbitration, I actually try and act like I wanted a judge to act when I was practicing law. I want to really understand the facts and I want to understand the law. In an arbitration, I'm a great believer in allowing the lawyers to present their case and to make their arguments. I want to sit back and wait until I've heard all the evidence before I try and make a decision. Emotion plays a critical role in mediations in particular. You have to allow them to express their emotions. You have to allow them to vet. And then once you've done that, you have to figure out how you channel those emotions into the resolution that you're hopefully crafting.